And I commend it to the House, sir.
Andrew Little.
Thank you, Mr Speaker. I'm happy to take a call on the Trustee Public Trust Amendment Bill. Mr Speaker, I can say this of the bill: we are supportive of the policy behind the bill, and we will support the bill. And I think the policy is a very sound one, that if the public trust is to be called upon as the trustee of last resort, in the case of collapsed finance companies or collapsing finance companies, it is only correct that when the retiring trustees who wish to wash their hands of their responsibilities are looking for an alternative, they should be required to have used their reasonable endeavours to look for an alternative other than the public trust. And then if, in an application to the High Court, the public trust is the only one left standing, then they should be reimbursed, or at least indemnified. Public trust should be indemnified for the costs of taking on that responsibility. Because the truth is that, certainly in relation to finance companies, we are talking about corporate trustees. They are there in the good times and they charge fees and generate an income, while the finance company is doing its best to take money and lend it, and whatever care or regard they may have for the investors and depositors with them. So they're quite happy to be there at that time and fleece the finance company and its depositors and creditors. But when it all gets going and all gets too hard, they want to flick responsibility and wash their hands of it. And so I commend the Minister for adopting that policy and taking that approach. The question remains, however, why this now has to be considered under urgency. And there are two principal reasons. One is that the issue that underpins this bill is not new. The finance companies have been collapsing since 2008. The risk of an application to the High Court to place the public trust or nominate the public trust or appoint the public trust as a securities trustee for a failing finance company has been there at least since 2008. And a question obviously arises, which is why the Ministry of Justice or the other appropriate authorities, or indeed the Minister herself or her predecessor, has not seen the risk and sought to move on it earlier. Now, in that regard, we have the Financial Markets Conduct Bill that is underway and is, in any event, if it is passed, is not intended to take effect until next year. But this is not a new issue. It has been around. And what we have is one application to the High Court by perpetual trustees to appoint the public trust as a trustee for capital and merchant finance. And interestingly, and the other aspect, the other policy aspect is, of course, that if that appointment, if under this bill, should it be passed, if it is the public trust is appointed, then the public trust, or the risk of loss to the public trust, is mitigated by the indemnity. That, however, won't apply in the case of capital and merchant finance and perpetual trustee, because the bill does not seek to be retrospective. That application has been with the court. It's due to be heard in a few weeks' time. And so any appointment of the public trust by the court cannot or will not take effect under this bill. The interesting thing about that is, and I've said this before about some of the personalities behind capital and merchant finance, one of them is Trevor James, who was a director of capital and merchant finance. Many directors, in fact all the directors of capital and merchant finance, have been the subject, if not of prosecutions by the Serious Fraud Office, and by that I mean successful prosecutions by the Serious Fraud Office, they have been the subject of civil action by the Financial Markets Authority. The one director who has escaped attention, for reasons that no one can understand, and for reasons that have never been given, is Trevor James. And the interesting thing about Trevor James is that he is a favoured appointee of this government. Most recently appointed to the board of none other than ACC. Appointed by the present Minister of Justice when she was Minister of ACC, still is Minister of ACC, appointed to the board of ACC as a consequence to the clean out of that board following their crisis last year. And of course he was not only appointed He was not only appointed to the board of ACC, he was made its deputy chair and the chair of their investment committee. Director of a failed finance company, a finance company whose other directors have been the subject of prosecutions by the Serious Fraud Office and civil action by the Financial Markets Authority, finds himself excluded from those actions and appointed by this government to the board of ACC and the chair of its investment committee. Now, in the words of that great English comedian Catherine Tate, I say, what a liberty! What a liberty! That should happen. That should happen. There's another word. There was another word, sir. There was another word in that phrase, but I understand it's considered to be unparliamentary, so I won't use it. But I simply say, what a liberty. It might do. It might rhyme with it. I'm not quite sure. It's a derivative of a word used, I think, by Aaron Gilmore not 2 weekends ago. But, sir, the point is this, is that C&M Finance and Perpetual Trustee, who is trying to absolve itself of any further responsibility of C&M Finance, will not have this bill applied to them. They've escaped the net. And it's only after they've escaped the net that the same minister that appointed Trevor Jones, a former director of Capital Merchant Finance, should seek to act under urgency to pass this legislation. And I just go back to what the Honourable Trevor Mallard said. That isn't necessary. There is already legislation being considered by this House that would cover the situation, and that is good. And as I say, the underlying policy is good. But this could have been dealt with in a way that could have allowed proper and full consideration. It's interesting seeing the regulatory impact statement of this bill that only became available to us mere mortals in the opposition today. It's interesting seeing the regulatory impact statement because they refer to the limited amount of time the ministry's even had to consider the matter. And they say they have not been able to fully develop even one of the options that they were considering. They talk about the inability to consult with other trustees who will be affected by the proposed options. And they talk about the inability to consult because of the litigation presently in the High Court. They talk about the lack of information about the financial implications of each of the options they were asked to consider before giving their report on this bill. And that the public trust has had no experience up to now of acting as a trustee for a failed finance company. These are matters upon which there should have been proper evidence given to a select committee. These are matters upon which there should have been proper considered deliberation by members of this House. And because of urgency, we will not have that. So we are flying blind. Not a blind trust, of course, but we are flying blind on this particular issue. And that is a matter of concern. When the issue could have been dealt with by simply saying in a bill that it will take effect from a particular given date, so that should legal proceedings by other failed finance companies and their trustees follow, there was then a clear signal and a clear warning that their legal action would be affected by the legislation before the House. It's been done before, my colleague Leanne Dalzell tells me. So there is no need for urgency, sir. And now under urgency, and all stages of this bill are expected to be passed now under this urgency motion, we will not have the benefit of considered evidence from experts and those experienced in the field. And we are in that position because of dilatoriness on the part of either the ministry or the minister and or her predecessor, and we are simply no better off. This is not good lawmaking, and we are in the unnecessary position of having to consider this legislation under urgency. And so while we will support the bill, we support the policy and the direction it's taking it, we don't support the process, and the minister is deserving of criticism, the harshest of criticism, for adopting this process in this particular way. And she can laugh and giggle. She's looking after her mate Trevor Jones, as she has all the way along, by appointing him to statutory roles. And of course, her track record in statutory appointments this year alone is not a very good one, but she's made it worse. She's exacerbated it by the passage of this legislation, which was totally unnecessary.
Julianne Genter.
Thank you, Mr. Speaker. I rise to speak on behalf of the Green Party on